motion? Filed on behalf of the news organizations listed, entitled Emergency Motion of News Organizations to Intervene and for Reconsideration of Implementation and Enforcement of Confidentiality Agreement is hereby denied.
Good morning and welcome back to In Session. I'm Ryan Smith and we have breaking news in the Casey Anthony murder case. As we speak, an appeals court is thinking about whether to delay the trial. And that ruling you just heard from Judge Belvin Perry, that's the reason why. Several stations and the Associated Press have appealed the judge's ruling about keeping the location of jury secret. The media say that having to sign a confidentiality agreement is unconstitutional, and the appeals court could back them up. A court official tells In Session that they know this is a time-sensitive issue, but they say they can't say when the judges will actually make the decision. Judge Perry has the petition, but he has not read it yet. Let's talk about In Session. Correspondent Gene Casares is outside the Court of Appeals in Daytona. In Session law enforcement contributor Mike Brooks is outside the courthouse in Orlando. And from New York, In Session criminologist Casey Jordan and criminal defense attorney Keith Murray are with us. Let's turn to Keith Murray. He's just joining us. Keith, in cases like this, is this, have you ever seen a judge really kind of pick up, and this is not something that was offered by the defense or the prosecution, have you ever seen a judge kind of step in and try to limit some of the things the media can do in order to ensure a defendant to a fair trial?
I haven't seen this up in Connecticut where I practice. I think Judge Perry here in this case has two that the appellate got to scrutinize. One is that for a judge to restrict or prevent media from a court proceeding, there has to be an evidentiary hearing. He didn't do that. He's kind of created, and this is the second prong, he's kind of created this little petty fiefdom here that he's created three classes of people. One class is people who agree with this confidentiality agreement and sign it. One class is people who don't agree with it and don't sign it. These two classes are going to get the information at different times. And then a third class who, if they sign it and then release the information, they get punished. There's a penalty. They get their press credentials revoked. So then if you have that situation, what do you do now? You can't just revoke the press's credentials without having some kind of hearing or some kind of fact-finding. So does that fact-finding then prevent the trial from going forward on time? I think he's created a morass here by doing this. I think it's entirely possible that just on the procedural grounds that the appellate court could reverse his order. And I think if he had just said, you know what, I'm going to let everybody know at 8 o'clock on Monday. I'm not going to decide, or 8 o'clock Sunday night. I'm not going to decide till then, treat everybody equally. I think he could have avoided this entire morass we're in right now.
Let's say they do vacate his order. Does that mean he comes back the next day and does exactly what you say? Could something like that happen?
I think it's entirely possible that he can come back and say, you know what, I'm just going to let everybody know Sunday night. But then the press is probably going to come back and say, well, if you know, you got it right now. Maybe he's going to draw a name out of a hat at 8 o'clock Sunday night, and that's how he's going to decide this thing. Maybe they'll have less of a problem with that, because then everybody's being treated equally.
Okay. All right, let's bring in our team of experts. We've got Gene Casares, our in-session correspondent, outside the 5th District Court of Appeals in Daytona. We've got law enforcement contributor Mike Brooks outside the Orange County Courthouse in Orlando. We've got criminologist Casey Jordan with us, and also criminal defense attorney Keith Murray as well. Keith Murray, one thing that strikes me in this case is that Judge Belvin Perry is trying to do whatever he can to ensure that Casey Anthony has a fair trial. But the evidentiary hearing part of this, as Gene mentioned before, there are 2 points they're contesting. They're saying it's wrong on a constitutional issue to put this restriction in, but it's also that he should have had an evidentiary hearing. Does he have to do that, or as judge, can't he have the latitude to be able to do whatever he needs to do, especially as the trial goes forward, in order to protect Casey Anthony's fair trial rights?
Even the judge doesn't have the latitude to subvert statute. And the statute in this case says that if you're going to prevent the media from covering an event, you have to have a public event evidentiary hearing showing why and meeting this certain standard. He didn't do that. Now, he may argue that he's not preventing the media from covering the actual event. The media is going to get the chance to be there for jury selection. He's controlling how they hear about it. Frankly, I think this whole thing is much ado about nothing. Casey Anthony is entitled to a fair and impartial jury. She's not entitled to a jury that has never heard about this case. You'd have to go to Amish country or Mars to find a jury, jury pool that hasn't heard about this case. And I think Attorney Mercier, made a good case for this in her statement. If the judge and these do their job properly in jury selection, the classic question, every single jury that's ever been impaneled in the history of jurisprudence is ask, can you put aside your personal bias and hear this case based on the facts as they're presented and the evidence as it's presented? If the juror asks yes, they're going to be impaneled. That's what jury selection is. That's what voir dire is about. And if they're all doing their jobs correctly, I think you could seat a jury in Orlando given enough time.
It says there has been no showing, and again, certain media outlets are filing this petition, there has been no showing of a serious and imminent threat to the defendant's Sixth Amendment rights to a fair trial. Keith, this makes me think, it makes me think that when we look at this particular case, some might say Judge Perry is being a little bit aggressive in handling this case. Isn't it his, let's say, responsibility to be able to be aggressive, as he can't second guess every single thing he does within this context?
No, and he may be being overly aggressive. I mean, you listen to the comments he's making, and he's basically indicting the media for doing exactly what they're allowed to do under the Constitution, under the Florida law, and that's disseminate information. The fact is the media has blown out this case, as he pointed out, with the websites and the access to court records on the websites and the access to even her, her jailhouse meetings with her parents and her brother. And we've got ourselves now in this catch-22 where the media is doing exactly what they're allowed to do under Florida law, and that's disseminate this information on this scale. And the judge is now saying, well, wait a second. That's actually hurting her right to a fair trial. So yeah, he's got to balance it, but I think in this case he's being overly aggressive, and I really do think that this, if he had just laid low and let it happen, let things go forward and release the location, I think he could have avoided this whole quagmire.
But you would have seen that mayhem right there, Keith, right? Or that's what Judge Perry's predicting at that courthouse. Would that have made a difference?
Well, that's the thing. He's predicting mayhem. There's no evidence of mayhem. We haven't seen any indication of mayhem that would happen at the courthouse as the juries, potential juries were being brought in and questioned. There's no indication that that's going to happen. There's always going to be some disgruntled public. There's always going to be some protesters. There's always going to be the media circus. But he hasn't put forth any evidence that this is actually or has happened or, has happened during all the evidentiary hearings we've been seeing for the last few months. There's nothing there.